So here is my best attempt at all of constitutional law in one page. The basic rule of American constitutionalism is this: before the government can forbid you from doing anything, it has to provide a reason. Because we say so does not count as a reason. To limit ordinary liberties, like selling eyeglasses, most any reason is good enough. To restrict fundamental liberties, like using birth control while engaging in certain activities I can't name given the group that's here, those are fundamental, and the government has to have a really good reason for limiting that. Now, getting to decide which liberties are fundamental is one of the cooler parts of being a Supreme Court justice. Under the Equal Protection Clause, even if the government has a reason for placing a limit on what you want to do, it has to explain why it treats other people better. Now, establishment of religion is really simple. Government prayer, bad. Private prayer, good. This is not rocket science. The only hard questions are when it's difficult, when a citizen uses government property or public funds for religious purposes, and the facts make it difficult to tell whether it's the government or the citizen making the choice, the religious choice. Those are hard, but that's the only complication. As for free speech, you can generally say whatever you want, but not necessarily when, where, or how you want. It's also okay for the government to regulate something called expressive conduct, as long as the government is going after the conduct part and not the expressive part. Also, and this is important, you have no right to dance naked unless you're a really good dancer, in which case it becomes art. Now, as for the First Amendment's so-called reporter's privilege to protect confidential sources, if you're a nominee, you don't have to worry about it. It's taught with great reverence in journalism school. Nobody mentions it in law school. Judges never heard of it. State sovereignty, I'll just skip over, but with this inside admonition, state sovereignty claims are more likely to be well received by this court when they're put forth by Alabama than when they're put forth by Oregon. Now, finally, it's very important to understand the doctrine of judicial restraint. This is the doctrine that judges should avoid legislating from the bench, but should apply the text of the Constitution exactly as written. This approach is very appealing to those who have never read the Constitution. But when you look at phrases that are actually in the Constitution, like the 14th Amendment, which requires judges to protect, without any further elaboration, privileges and immunities of citizenship, liberty, equal protection, phrases that are so open-textured that they make the admonition to apply exactly as written somewhat unhelpful. Finally, senators really like it when a nominee says that a judge's role is just to be a, quote, umpire, unquote. But broad constitutional phrases are different from sports rules. Now, a judge would be like an umpire if the game, instead of having a strike zone and a set number of balls, strikes, and outs, provided instead that each batter shall have a fair chance to hit the ball, or each team shall have a reasonably equal opportunity to score runs. Key language of the Constitution is that broad, meaning that men and women appointed to the bench must necessarily exercise judgment, which is, of course, why they are called judges and not umpires.